So the majority of the times that I have given presentations that Stephen mentioned have been to groups of attorneys, usually county delinquent tax attorneys, other tax collectors, title insurance agents, etc. So forgive me if this kind of takes on the tone of a legal CLE. As Stephen mentioned, I was representing Williamson County and its cities up until recently. Where I am now, I'm largely representing tax sale investors, which I've been doing for some time, and then also involved in the real estate group where we are doing a lot of real estate and lending, transactional work, loan documentation, etc. Just to start with a general overview of Tennessee tax titles, one large difference between Tennessee and what you've been hearing about this morning is that Tennessee is a tax deed state. So what that means is when you go to a tax sale in Tennessee, you're not buying a certificate, you're not buying a lien, you are buying the actual property. And we will get into all of this throughout the presentation, but there is a one-year right of redemption. And once that redemption period is over, if you were fortunate enough to make it through that redemption period, you're supposed to have a perfectly clear title from that point. But the actual tax sale itself is a conveyance of the fee interest in the property, subject only to that right of redemption. So just briefly on the overview, in Tennessee there is no state property tax. It's all done by the counties and municipalities. There are also some special school districts and drainage districts and things like that can have property taxes as well. But the taxes are assessed annually, as they are most places, on all non-exempt property. January 1 is the effective assessment date. Rates are set during the summer, and then the tax bills come out in October, and you have until the end of February to pay them. Taxes are not paid by March 1, they become delinquent. Now, on that January 1 assessment date, a first lien goes down on the taxed property. In Tennessee, it's a very strong lien, as it is in most places. The statute specifically refers to it as the first lien. And every single case that has ever interpreted that has held that the ad valorem tax lien has priority over absolutely anything else. Now, that doesn't matter if your mortgage was recorded before the taxes were assessed. It doesn't matter if it's personal property and it's a PMSI that existed before it. The Tennessee tax lien has supreme priority over all other claims against the tax property. And of course, that's the foundation upon which the tax sale titles are built, and basically the whole reason why anybody's willing to invest in them. The way it works procedurally, the county trustee, who is the county tax collector, selects a delinquent tax attorney. And a lot of the bigger cities, bigger jurisdictions, it'll be an in-house lawyer for the most part. More rural places, it'll just be a local attorney. The firm I was with were in Williamson County, which is Franklin, Brentwood. It's the suburbs here, and that firm had been doing it for probably 40 years. And just had a very good relationship with the county and cities. But the county trustee selects the attorney, the mayor approves the attorney, and as I said, the taxes go delinquent on March 1st. You can't actually turn them over until the following January 1, but then you have to do it before April 1. The delinquent tax attorney files a mass lawsuit in the Chancery Court before April 1. What that is basically just a holding bill with a big stack of delinquent tax records. And the last point on there are 95 counties in Tennessee. All of them, of course, have cities. The cities can file separately, or they have a right to join in with the county. And it's kind of a mixed bag as to what you get. What we were doing in Williamson County, we had everybody together and it was all one lawsuit. A lot of places you'll have county and city running separate lawsuits, and so you have to watch out for things like buying a property for county taxes, and then all of a sudden there's a pending suit by the city for the same year's taxes that's still out there that you have to take care of. But for the most part, there is at least some degree of coordination between the counties and cities. So it is an actual lawsuit, and the delinquent taxpayers and any other interested parties, meaning the lien holders or new owners or heirs or whoever that may be, anybody has an interest in the property, is entitled to due process, which is notice and an opportunity to be heard. And that goes back to the United States Supreme Court cases. The Mennonite one is the one you hear mentioned the most. It's from 1993. It goes back a lot further than that. That's just probably the one that contains the best summary of it and the one that gets cited the most. So they're entitled to the opportunity to be heard. But as a practical matter, there's not really much to be heard about. I apologize for the small print here, but the bottom line is by the time you get to court, there's really not a whole lot that people can do about the delinquent taxes. Tennessee law is set up heavily in favor of the taxing jurisdictions. If the taxpayer has failed to administratively appeal the assessment, then by statute, the assessment is deemed conclusive. And certified tax rolls are prima facie evidence, which basically just means that if you come to court, the burden is on the defendant, on the taxpayer, to prove that it's incorrect. It's a high hurdle for them to jump. And then the third point there is that anybody that may fall through the cracks and of not having the defense of the administrative remedies, but anybody that wants to challenge the constitutionality or anything else like that, they're required to pay the taxes under protest and then file their own lawsuit seeking a refund. And the bottom point there shows that it's been held many times. The State ex rel. Davis was the most recent case that I'm aware of, but you can probably have a string side of about 20 different cases saying that if you don't either exhaust your administrative remedies or pay under protest, then you can't just answer the delinquent tax suit and have a trial over whatever you want to. Process has to be served on all delinquent taxpayer defendants. There's a distinction between service of process and notice, and this causes a lot of problems with tax titles and getting underwriting done. The delinquent taxpayer is the person who's noted on the tax rolls, who had a personal obligation to pay the taxes and who is personally liable. It's their property that's being sold, regardless of how much equity they may have in it. They're required to be actually served just like any defendant in any lawsuit. The lien holders, such as banks with mortgages, et cetera, in some counties are served the same way. Williamson did it that way. They would go ahead and run the title search on the beginning, figure out, Bank of America's got a deed of trust, Discover Card has a judgment lien. We would go ahead and make them defendants on the front end, get them actually served with process, take a judgment against them, the judgment being a declaration from the court that our lien was superior and knocked it out in the tax sale. And then all this stuff is cleared out. It's taken care of, it's on the record. Nobody can ever challenge the fact that they were served. It's not done that way in a lot of counties. And technically, it doesn't have to be. If somebody just has an other interest in the property, such as a lien holder or a new owner, then they're really only entitled to be notified that the tax sale is going to take place and that they need to preserve their collateral. The result of that is that a lot of the problems we see and a lot of the problems they spend their time dealing with are failures to properly notify lien holders. And that happens a lot. And quite frankly, a lot of, especially the bigger jurisdictions, just simply don't have time to be as thorough as they probably should be about these things. But that's sort of something that cuts both ways, because you do want the clear title, but at the same time, Williamson County, doing it the way it does it, sells an average of about 5 properties a year. And while it's a wealthy county and may not have the same volume naturally, we always thought that the main reason for that was the fact that if you put more pressure on these banks and other interested parties, they don't want their collateral at risk. And so what they'll do is they'll go in and they'll pay the taxes to avoid the sale, charge them back to their borrower, et cetera. And so being aggressive on the front end with lien holders was a good way to get the taxes paid early for the county, which results in fewer properties being sold. So it really does cut both ways for investors. I mean, you want there to be a higher inventory of properties to choose from, but when you buy them, you actually want to be able to resell them. You want marketable title. And it's hard to find a good balance there. let's see. Service by certified mail in a delinquent tax suit is very common. In a lot of cases, these properties are abandoned. Nobody's living in them. The county's going to have a hard time finding the taxpayer or the owner anyway. The preference in Williamson County was to get serviced by the sheriff whenever possible. Again, it's to encourage voluntary payment, but also then you have the return, and there's no question down the line about somebody's title. But certified mail is pretty common for service, as is service by publication, which what that means is if you're not able to get somebody served at all, aren't able to get anything signed, then it basically is just published in the newspaper, which we all know these days how many people actually read that and see that. It's a technical defense to having tried to serve somebody, but as a practical matter, it's generally not giving people actual notice. One of the big problems you see come up in Tennessee a lot is that by statute and by the rules of procedure, if you send service out by certified mail and it comes back with a stamp or an indication that it was unclaimed, what that means as a practical matter is that the address hasn't been changed. There's no indication that the address is wrong. It just means that the mail didn't get to the person. So in a lot of cases, yeah, the people just won't have picked it up, or they will have ignored it or refused it. But it also could mean that that person just hasn't updated their address with the Postal Service. So it's very common. A lot of the properties that get sold around here will be the judgment, the service that led up to the judgment will be based upon unclaimed certified mail. Technically, that's good service. Technically, that's okay. And a lot of counties will just stop right there and they'll move for a default judgment. There is some question and some concern about whether a default judgment can be based upon unclaimed certified mail based on language of another rule of civil procedure and a couple of cases that don't have anything to do with taxes. But the bottom line is underwriters hate unclaimed certified mail, and they don't want to base anything on unclaimed certified mail, and understandably so. So what really should be happening is these counties, when they get that back, they need to take another step. They need to try and locate another address and get actual service, or they need to at least move on and also do a publication just so there's something else you can point to that we tried to give them notice. And unfortunately, it varies county by county, city by city as to what level of follow-up there is on that. So we do see a lot of trouble with unclaimed certified mail. Another problem we see a lot of is with deceased delinquent taxpayers, which are very common. Rather than having done the research and identified who the heirs are and substituted them as defendants and served them, we'll see the heirs and claimants of John Smith. And that's all that will be on there, and the address of John Smith and the service return will show unclaimed, and that's it. And when you're looking at it from a clearing title perspective, you see that, and there's just not really that much you can do with it. As will be discussed later, that does lead to a lot of quiet title type work. But that's very common, especially in the larger counties around here. There's not, the tax lists are so lengthy, the workload is so high that it's difficult for them to do that sort of research on the front end and make sure that the proper people are getting notice. What they prefer to do is sort of whittle it down, and by the time they get their default judgments and get ready to send things to sale, then they're doing the title searches, so they're doing a smaller number of them. However, when it comes to these estates, the only time they're picking up who the heirs are is if there's been an actual probate filed, because they're required to do that by statute. And I think you could probably draw a connection between people where taxes haven't been paid for multiple years and people whose estates did not go to probate. I think those line up together fairly often. Again, some counties do the title search early on, Williamson in particular, a couple others. That gives you a better indication of who needs to be notified, and also results in voluntary payments, which again reduces the inventory. If you're unable to serve somebody, you still have to exercise due diligence, which is a hazy standard. One Once everybody does get served, you do have to get a judgment in order to take it to tax sale. A tax sale in Tennessee is an enforcement of a judgment. It's a judicial procedure, and I'm sure to some degree, pretty much every state is that way. But there has to be a valid judgment in order for there to be a valid tax sale. So once you've gotten that judgment, if it's by default or if somebody's filed an answer, it can be by summary judgment or judgment on the pleadings, the matter gets referred to the clerk and master, who is the clerk of the Chancery Court, which is where delinquent tax items are usually held, who determines the total amount owed. The court confirms that report and then orders the property to sale. The sale or the delinquent tax action is an enforcement of the lien, and it's also an enforcement of the personal liability. So technically, counties can go after other assets of the taxpayer rather than selling the property. For the most part, that doesn't happen. In my time, the only time I ever really saw that done would be where, say, a developer who we had other information on, a builder, had a drainage ditch or something like that we knew nobody wanted, and we had a check image from something else or something like that where we knew we could enforce the judgment. And the problem is if nobody comes and bids on the property, it goes back to the county, and the county, of course, doesn't want it. So that's the only time that ever really happens. But before the sale, the county and city are required to run a record search. Now, this kind of gets mixed in with the idea of the title search to get everybody properly noticed in the beginning. But this is supposed to be a separate procedure. What this is supposed to be is after you've gotten everybody served, you're supposed to do this search to determine who else needs to know about the sale. And this requires a search of the public records. It's the tax assessment records, the probate records, anything else that's public record you have to look at and determine who needs to be notified of the sale. The sale is then scheduled, and the clerk and master publishes a notice. The notices are supposed to be mailed out to every interested party, everybody that's identified in that last search. The notices can be sent by regular mail. Surprisingly enough, that's all you may find. And this has been a real problem for people. So not to pick on the metropolitan government in Nashville and Davidson County, they're just the one I'm the most familiar with because I practice here. But they had a case in 2006, this beneficial Tennessee case, where a lien holder challenged a sale on the basis that we never got a notice of this thing. And Davidson County's response, Metro's response was, well, sure you did. Here's a copy of the notice we mailed to your registered agent. It's sitting right here in the file. This is all that's required under the statute. I said, well, this could have been sent anywhere. There's no proof that nobody signed for it. There's no certified mail card. There's nothing showing that anything happened other than you mailed it. And the court said that's all that's required. So if you buy a property in Davidson County and you go afterwards and you take a look at the file and want to make sure that everybody's gotten proper notice, because you're not going to see that before the sale, that's what you'll see. It's just a regular letter addressed to somebody. In some counties, they'll do the same thing. They won't even date the letter, which is particularly difficult. But they have a court of appeals case they can point to that says that that's okay. As anybody who deals with title insurance on an even semi-regular basis knows, just because the court says it's okay doesn't mean that somebody wants to take the risk and underwrite the policy. So that may not get you where you need to be in the first place. So that means you may not find anything other than that letter, which is not always very helpful. Sales conducted by the clerk and master. The opening bid is supposed to satisfy the judgment amount, which is going to be, let's say we're working on a 2012 delinquent property tax list. Your opening bid amount should be the 2012 taxes, plus there's 18% penalty and interest that goes on that, simple interest. Other statutory and court-ordered costs and fees, that'll be your filing fees, your attorney's fees, your title search fees, etc. Now, there's another statute in Tennessee that says anytime that the clerk of court sells a property according to a judge's order, that they have a requirement that they bring all the taxes current that are owed on that piece of property before they can disperse money to anybody else, and before the sale can be properly confirmed and it can be a good sale. The Tennessee Attorney General has suggested that that does apply to tax sales as well, but this is something that's not enforced across the board. The disagreement is as to whether that initial bid amount needs to be high enough to cover newer taxes. So if it's 2015 and you're buying something based on delinquent 2012 taxes, you're going to be on the hook for 2013, 2014, and 2015 if the bid amount isn't high enough to cover those. And in a lot of counties, they'll even argue that it doesn't matter if the bid amount's high enough. They want your money instead. They actually care who the source is. In a lot of cases, they want it to just sit there and rack up 18% interest. They're not supposed to say that. Some of them actually have. So for instance, in Williamson County, when we would sell a property, what we would do is that opening bid amount wouldn't just be the 2012 payoff. It would include your 13s and 14s. And now, because the bills are out and everybody knows what the 15 taxes are, we'd bring the 15s in there also. That's a good thing from your perspective because you don't have to worry about it. You truly are getting clear title. You don't have to worry about 11 months later getting served with process for unpaid 2013 taxes as the new owner, which I've seen happen. It also, while there is some downside, I understand, to having the opening bid amount higher, ultimately, if you're going to keep the property, first of all, the redemption premium, which we'll get into in a minute, is going to be calculated based on your purchase price. So that just means that somebody's going to have to pay more to redeem it. They're less likely to do so. You're going to save the 18% that would be on there. And I mean, you're going to avoid that altogether. It also makes it less likely that somebody's going to be able to come in and stop the sale. So if nobody bids, if that opening amount is too high, if the property's no good, the clerk and master is required to place a bid for whoever's prosecuting the suit, and they take it back in, and it becomes property of the county and or city. There's a specific procedure for reselling properties. It's a practical matter. If nobody bought it at the tax sale, they're not going to want it later. So that generally isn't all that effective. And counties taking properties in at tax sales lead, of course, to all kinds of different problems. And for that reason, I've always suggested that there's a tendency, especially I think in rural counties, for the court personnel especially to view buyers as almost kind of a nuisance, that you're causing them to take more time out of their day than what they normally have to do, and you're in there trying to make a profit at the expense of these poor people, and the same kind of attitudes that we saw earlier with the bad press. And one of the things that I've in speaking to these groups around the state tried to impress on people is nobody wins when the county takes in the property. It causes issues. The county has to deal with it. They have all kinds of potential liabilities for it. I mean, there have been counties in Tennessee that have been hit with several $100,000 judgments for not paying later HOA dues on properties that they took in on dead neighborhoods, basically. The counties are not supposed to be in the business of buying and reselling properties. What they want you all to come in and buy the property, fix it up, get it back on the rolls, make the neighborhood look nicer, start having the revenue stream come in when it's supposed to. And they need to be viewing the investors as their partners in this, rather than as the enemy. And I think there's been sort of a change in attitude a little bit, at least among more of the urban and suburban parts of Tennessee, but it's still a real problem. There's a change in mindset that really needs to happen, because it's not a good thing for anyone when the government takes the property back. The winning bidder pays the clerk, who files a report. The reference here to the new statute, there was a problem that was what was happening from an underwriting perspective, is that a property would sell, nobody would ever record anything in the registrar's office. And so the delinquent taxpayer would find a buyer and go to sell it a couple months later. They'd call the county trustee's office, who'd look at the records and say, no, it's been paid, because it was paid out of the sale proceeds. They'd call the clerk and master, who would say, no, we don't have an active case on that property. And then they'd look in the registrar's office and there wouldn't be anything recorded. So they'd go ahead with the sale. Meanwhile, it's still sitting there in the redemption period. There's been a sale of the property, and you can imagine the kind of issues that come up with that. So now, effective 1/1/16, there's a requirement that the clerk and master record that report of sale. It's sort of like what you'll see in some states, the appointment of substitute trustee, which is basically just, it's notice to the world is one of its primary functions that there may be a foreclosure coming up. Serves the same kind of purpose. It doesn't actually transfer title. All right, the court then enters the order or decree confirming the sale. That actually conveys the fee interest in the property. I mentioned at first that Tennessee is a tax deed state and not a tax lien state. That's when the fee transfers. It's not a tax certificate or lien, and it's subject only to a right of redemption. So conceptually what happens at that point is the delinquent taxpayer, and let's say Bank of America and Discover Card or whoever else has interest in the property, those interests are no longer, they get converted from a fee interest or a lien interest into a statutory right to redeem the property until that right is exercised. And that fee goes to the buyer. The buyer, now being the fee owner, has an immediate right to possession as soon as that order is entered. And this is something that very few people are aware of in Tennessee, but by statute, you as the buyer can file a motion with the Chancery Court where the property was sold, asking for a writ of possession as the property. You don't have to file a detainer warrant action in the lower court and go through all that stuff and have extra service. You just ask the court to enter the order directing the sheriff to conduct an eviction. And it doesn't matter if there are 11 months left in the redemption period or not. You can do it then. And this is advisable. I mean, first of all, there's the idea of it, if somebody's going to redeem it, you'd rather know so you can do something else with your money. But being the fee owner, as a practical matter, the risk of loss is transferred to you. So if something happens to this property and you don't have it insured, it can be a real problem. And it's, you can probably point to some correlations between the types of properties that end up in tax sales and ones that end up, especially in some of the rural areas around here where people are running meth labs and things like that. You don't know what's going to happen to that property during that year. And if all of a sudden there's a quarantine put on it or it explodes or something else happens, your money is down the drain. So it's advisable to at the very least get insurance on the property, but this is the reason why there's an emphasis on this. It's not, while there is there is the idea of, moving the process along, it's for the protection of what's your property. Now, as I mentioned, all interested parties, everybody who has a legal or equitable interest has a right to redeem the property. That lasts for 1 year from when the sale is confirmed, when that order goes down. It can't go a day after that because it is a statutory property right. It's not an equity. And there's a United States Supreme Court case analyzing the Tennessee statute that says you can't, for any reason, equitable or whatever, extend that redemption period. If you're past the redemption period and you have a problem with what happened, you need to file a lawsuit to set aside the sale. You're not going to get to redeem it late. In order to redeem, you're supposed to file a motion. As a practical matter, it ends up being a lot more informal than that. The group I was with changed the statute a couple of years ago to make it a motion, trying to get away from that. And it's been kind of slow to take hold. The redemption interest that you're entitled to as a buyer if the property is redeemed has changed twice in the last 2 years. And just as a quick aside, the group I'm referring to, the Tennessee Association of Property Tax Professionals, it's a group made up of delinquent tax attorneys, county and city tax collectors, court clerks that deal with this kind of stuff. And over the past, 4 years really, that group has drafted and lobbied and gotten passed changes to about 80 different sections and subsections of the code, and all dealing with delinquent taxes and tax sales. And one of the areas where we've put in the most work has been on this redemption, on these redemption areas, because it was done 95 different ways, 95 different counties, 95 different procedures, and nobody seemed to be really sure how these things are supposed to be calculated. So for sales before July 1, 2014, which unfortunately we're still dealing with a lot of, it was a 10% per annum premium calculated daily, and nobody knew when it was supposed to end. So you would get differing results in different counties, as opposed to if you get interest calculated for the whole time your money is tied up in court, or if you only get it until the people file the paperwork or whatever else. So in 2014, it was changed to make it a monthly calculation, where 1% went on the first day of each month after the sale. You got an immediate 30 days, no matter what, you're 1% back, and then another percent was added each month after that. Well, even though the clerks had suggested that and requested it, that ended up causing a lot more problems with clerks' offices. So this year, for sales occurring May 2015 and after, we've gone back to the daily calculation, gone back to the procedure that was in place before. We've kept the 12%. So there was ultimately an increase in the rate, but it's back to a daily calculation, and there are very defined cutoff rules, as opposed to before when it was just open-ended, and this, I won't go into too much detail about this, but essentially what's supposed to happen is for the entire time you're without the use of your money, it's supposed to be drawing interest. And I think we've managed to bring that into the statute and make it clear. What I've been spending a lot of my time on, as have a couple of other people in this room the last year or so, is dealing with problems coming from people buying and selling redemption rights. And redemption rights are freely conveyable. They're a property right. That's become very common. The problem is it is open, very ripe for abuse. And that has happened here. There's a large class action lawsuit going on here in Nashville alleging some fraudulent activities in that, forgery of notary seals, et cetera. But this is, whether, regardless of the outcome of that case, there's no question that this practice has caused a lot of work for different clerks' offices, for different attorneys, for buyers. There's been tons of litigation that's come out of this. The reason why the right of redemption is conveyable, it is a property right. But the benefit to that is, the delinquent taxpayer ought to be able to make a decision as to what they want to do with their property. If it's a better deal for them to sell to somebody as opposed to redeeming or whatever, because they're not going to be able to afford to renovate the property or whatever, then yeah, you don't want to take that right away from them. But it's something that has gone largely unregulated. The practice isn't actually addressed by statute here. It's addressed by statute dealing with other real property foreclosures, but it specifically exempts tax sales. So that's something that is being worked on legislatively right now, and it is being worked on in litigation as well. So we'll see how that turns out, but it has eaten up a lot of people's money and time dealing with those problems that come from that practice. But when somebody files a motion to redeem a property you've bought, you've got an opportunity to object to it and to claim reimbursement for certain additional expenses. Generally, there's a difference between whether an expense is to maintain and preserve a property or to improve it. If you're patching up a leaking roof, where if you don't do it, the property is going to deteriorate even further, that's obviously maintenance and preservation. You're going to get your money back. If you install a swimming pool in the backyard, that's obviously to improve it. You can't just run up the costs so that the person that can't afford to redeem it, at least you're not supposed to. And so that's going to be considered an improvement, and the court is not supposed to allow you to do that. This case here, the Provident Properties case, has a wonderful goes into several pages dealing with cases from around the country, analyzing different claims, because this, I think, is a similar standard in just about every state. But it talks about different claims that people have made for reimbursements and redemptions all across the country, and what's been allowed and what happened and what hasn't, and sort of differentiates between maintenance and improvements. So if the redeeming party establishes that they have a right to redeem and they've paid everything they're supposed to, the redemption's complete, and there should be an order that goes down and gets recorded immediately in the registrar's office. And another issue we've had to work on legislatively is what is the difference, or what is the meaning of an actual redemption? What happens? The statute that was in place before July 1 of 14 so that the redeeming party would be transferred the taxpayer's interest in the property. Seems simple enough, but it's not. The next sentence that came after that said that any redeeming lien holder can then proceed to foreclose on their lien. And there's also a statute that said that after the taxpayer redeems, there can be no further redemptions. Well, as I mentioned before, there are 95 different counties and 95 different ways of doing things, and several different ways of interpreting the old statute saying that the redeeming party gets the taxpayer's interest in the property. Some lenders were viewing this as a way to get around actual foreclosure, saying that, well, if we go in and we redeem the property, we knock the taxpayer out completely, we knock our borrower out, we don't have to foreclose, notwithstanding the next sentence of that old statute. There are some, and some are still making this argument today, that if you buy somebody's right of redemption, let's say an heir that owns 2% interest in the property, and you go in and you're the first one to redeem, then that 2% gives you fee simple absolute title in the property. That argument actually is currently being made. I think that just as a very basic general matter, the word interest is significant there, and it's clearly the idea is supposed to be you just get whatever equity they had. If the taxpayer's underwater on a piece of property, you can't knock out the lender. That should be, you would think that would be obvious. Still, it was causing problems with interpretation. So in 2014, the legislation changed that language, and after a lot of debate, we tried to make it as simple and as clear as possible, and it was written to say that a redemption just sets the sale aside. You think that implies that it just goes back to the state that it was before, which is what's supposed to happen. Well, that caused all kinds of problems again. So, for sales occurring after May 8th of 2015, the result of the redemption is that the interests of the taxpayer and other interested parties, or their successors in interest, shall be restored to that state which existed as of the date of entry of the order confirming sale. In other words, we're restoring it to the status quo at the moment the sale was cried. Going back to where it was there, and hopefully that will take care of it from now on. But redemption was not supposed to be a process for people to come in and be unjustly enriched. You're not supposed to be able to gain equity in property by not paying your taxes. If that argument that I was referring to a second ago about getting the taxpayer's interest, the logical, where that leads logically, is if that interpretation were correct, then every single one of us should just stop paying our mortgage, let our property go to sale, go in and redeem it, and then all of a sudden we've knocked out our mortgage. And of course it doesn't work that way. Sir?
Now, isn't that actually how the IRS right redemption works, though?
The IRS right?
If the IRS exercises their right to redeem I don't know, I'm from Arizona, Tennessee, but they have a right to redeem under federal law for 120 days after the sale date.
Sure.
And as I understand how that operates, it's not restoring title, it's giving the IRS all rights of the foreclosing party to the property.
I'm not as familiar with the federal statute, and I know IRS redemptions are specifically handled by that statute in the U.S. Code annotated. My understanding of it, where I've looked into it before, is that the IRS doesn't have lien priority automatically over prior recorded mortgages, et cetera. And I don't believe that they can just step in and knock out somebody with higher priority through a redemption. I think it restores it. I don't think that they can add to their equity that way. Now, I can certainly see an argument that if there were something that were further down the line, a junior lien, that it might be wiped out by the IRS, because the IRS could be arguing that they're enforcing their lien, and so therefore it's essentially a foreclosure. But I'm not as familiar enough with that issue specifically to say for sure, but that would be my first impression of it. It would be that it depends on just basic priority rules.
I think you have a great point in that Treasury regulations probably suggest that the IRS right to redeem springs into action when the state right to redeem expires, right? And nobody has stepped forward to exercise their rights in their state.
Well, I think that 120 days runs from the confirmation of the sale. I think it's concurrent with the state right. But I think as a practical matter, while the federal law is going to is supreme, where it's silent, you've got to look at the state law. So in that sort of situation, if the IRS, and again, I'm not familiar with the ins and outs of that statute, but let's say that the property, let's say the IRS lien isn't very large. Let's say you've got a $300,000 house and the IRS lien's only $100,000, and there's $200,000 more in equity. You've got to consider that situation. But you've still got 245 days worth of state redemption period after that IRS period is over. So I haven't seen that come up yet. Has anybody had that? In the back?
I've dealt with the IRS a few times, and usually it's after the redemption period has expired.
Okay.
When they get the additional 120 days.
Okay.
And then they'll step in, and there's one of two options. Either you redeem them in an instance like that with a house that's more value, you negotiate to get a release from the IRS, or the IRS redeems you. And they
Yeah.
still have it from close on their side.
I would think that you would have what the IRS is doing there, you would have a right of redemption on, essentially, where you could get it back from them. The one area where I've gone head to head with the IRS on something, their position was not that it was an additional 120 days. Their position was that during that 120 days, they could use their procedure to redeem under that. But after the 120 days are up, they're just like anybody else that has a right of redemption. So for the next 245 days, if the IRS wants to redeem, they've got to go under the state statute just like anybody else. And so we had a case where the IRS didn't get their check cut in time and submitted a check to redeem a property as a week or so after the redemption period was up. And I was representing the buyer, and we said absolutely not. There's no exception for the IRS. The right of redemption is it's a specific property right. And the United States Supreme Court has been very clear on this. The Tennessee Supreme Court has been very clear. It doesn't matter that, somebody in one department didn't talk to somebody in another and they didn't get the check cut in time that they ordered a month ago or whatever else, that might give you some sort of argument or equity in some other kind of case. That it doesn't matter. That cannot contradict a specific statutory requirement. And we were successful on that argument. The IRS redemption was denied, and the buyer got to keep the property. Again, without having the federal statute in front of me, it's hard to say, but I know that there is that difference between the 120 days and the additional 245. And I think it truly does become a case-by-case thing. All right. So assuming you've made it all the way through the redemption period, because the tax sale is an enforcement of the super priority first lien, all other liens are extinguished by a completed tax sale. Thus, if that weren't the case, there'd be no need to notify the lien holders in the first place. Their collateral wouldn't be at risk. None of that would be there. So essentially what happens, as I said before, the confirmation of the sale converts all the other interests under 1 year rights of redemption that expire after a year. If any are exercised, they're all restored, and if they are not exercised, they disappear completely, and you've got fee simple absolute. And by statute, the tax deed from the clerk, which you don't actually have to have a tax deed. A tax deed is sort of additional. The confirmed order of sale that's been recorded serves the same purpose. But a buyer who makes it to that point through the redemption period with the property, it gets an assurance of perfect title under the statute. And that's what that's referring to. If you make it all the way through, that right of redemption goes away, you've got perfect title. But just because you can convince a judge of that does not mean you can convince an underwriter of that. Problems with service and notice are huge issues. Pretty much, we deal a lot with potential due process violations with people who, lien holders or heirs or whoever else, are saying that they didn't get proper notice. Again, 95 different ways of doing things. The counties are overloaded and they just simply don't devote enough time to it. So, as I mentioned, there's been a legislative effort the last few years to address these problems. And a few years ago, there's a group of us that was largely representatives from the 4 biggest jurisdictions in Tennessee, which are Nashville, Memphis, Knoxville, and Chattanooga, along with some others, met with a group with, you might be familiar with Professor Frank Alexander out of Emory. He wrote a law review article a while back on tax sale due process, and I think he sort of led the charge and wrote the legislation that changed Georgia's tax sale statutes a few years ago. Frank Alexander is a professor at Emory, and met with him and some other folks and talked about tax sale modernization and some ideas for that. We've had a lot of revisions over the last few years, but it has been kind of piecemeal because there are a lot of different statutes to deal with, and quite frankly, especially when we're dealing with, these groups are largely made up of attorneys for governmental entities and state personnel and all that, and there's only so much time you can devote to that, and so it's an impossible task to tackle the whole thing without having that the plan in the first place and everybody having buy-in from a lot of different groups. So the TAPTP has led that charge and has done a lot of good things and has, as I said, changed about 80 different statutes and sections and subsections of the statutes. But the goals of that group have been to modernize and standardize the process so that you don't get a different result in Nashville than you get 2 counties away in the country. And so that it becomes predictable. And so that, as I mentioned before, the county should want y'all to come and buy properties at sales. There should be sort of a partnership. That should be the idea. And so therefore, increasing the marketability of tax sale titles is a very important consideration. And that all goes down to title insurance underwriting for the most part. But that's been one of the primary focuses of that group, is increasing the marketability. And so we've worked with the title insurance groups. We've worked with lots of others to make sure that we've considered all these ideas. Nonetheless, regardless of what you do legislatively, you can sue anybody for anything. It doesn't mean you're going to win. And so no matter what you do legislatively, it's not going to prevent somebody from making a claim. And there's always inherent risk. You've got third-party vendors, tax title services, et cetera, who will do due diligence searches. However, I think the bottom line, when you get to that state, the safest protection against future claims is a res judicata defense. And I don't mean to get too much into legalese, but the idea there is you only get one bite at the apple in court. And a lot of the problems you see with tax sales are that the person didn't get proper notice. But if you file a quiet title lawsuit, now substantively it's supposed to go in and say you have a right to the property. All these people appear to on the public record, but they really don't. So we need an order clarifying that. And yes, there is value in the substance of that. But the true value of a quiet title action and a quiet title judgment is this res judicata effect. You go in and you get proper service on the delinquent taxpayer and the lien holders that the county may not have done as good of a job getting service on or notifying, and they are forever barred from coming in and making any claim that they might make in the future. It's called the res judicata. There are a lot of different ways to clean up titles, but ultimately, if you've got a problem, if you can get that, then that's going to be about as good of a situation as you can have there. I think that pretty much brings us to the end of the prepared materials. Does anybody have any questions on anything? I know this is, as I said in the beginning, this is I've largely done these as legal seminars, so I apologize if it takes too much of that tone. Yes?
If a property is blighted or condemned, will it expedite the redemption period at all?
Good question. Shelby County, which is in Memphis, has had a real push over the years of dealing with blighted properties. And the group I met with that met with Professor Alexander was a group that was focusing on blighted properties. And Shelby County's done a lot of good things. They have a land bank. They put in a lot of work to reducing the inventory there. And they had a bill this past year in the state legislature that attempted to tackle that very idea. And it was a pretty lengthy statute. And what it did was it said that, and I'm not going to try to recite all the details because I'm sure I'll get it wrong, but it allows for stepped down redemption periods in certain classifications of property. So in other words, you can have something established by the court to be, I think it's abandoned or vacant. I forget the exact language, but there's a 6-month period, there's a 90-day, and I think a 60-day might be the shortest. And it you've got to do inspections of the property and get all this stuff certified. There was some concern legislatively that it was a mandatory provision, and what was going to happen was that, even if it's a very simple title search and no problem with it, and the county could just put it straight in, that they were still going to have to do all the site visits and all that. So the compromise on that bill changed it from a mandatory to a permissive thing. So essentially, if the county wants to get rid of a blighted property that it doesn't think that a regular buyer is going to want, and it feels like it needs that shorter redemption period to motivate people to come in and bid on it, the delinquent tax attorney can file a motion with the court asking to establish that the property is abandoned or vacant and to order that it be sold subject to a shorter redemption period. So that statute, I believe, is in effect. I believe it went in effect in either June or July. It applies to all counties, but it's a permissive statute. So if you go in and you buy a property in Nashville and somebody comes and redeems it on the 364th day, and you say, wait a second, this was an abandoned property under that statute, they shouldn't still be allowed to redeem, you're not going to win in that argument, because unless the county actually took the step of getting that order from the court saying that, then it's still 1 year across the board. And there has been discussion about lessening the redemption period across the board, maybe going to a 6-month or something like that. There's a lot of differences of opinion about that and the right way to do so. But it's on the table and it may change. But for right now, it's going to be a year unless there is a specific situation like that. Sir.
Yeah, thank you for your talk. I think it's really informative.
Sure.
I apologize if my questions not sufficiently well informed. But going to this last point on your slide about the res judicata defense of quiet title action,
Mm-hmm.
I think of res judicata as a shield and not a sword.
Mm-hmm.
And so if you bring a quiet title action to confirm or confirm the title, What is your allegation in there as to the main defense? I presume you get a title report, gives you the universe of people with potential
Right.
claims of record. You're going to join in the suit, and you're just essentially alleging they no longer have an interest and it should be stopped from ever making a claim. So you ultimately get a verdict that says that, right?
That's right.
Do you introduce this concept in the complaint, or it seems like that would be a defense in a motion to set aside?
Well, what you're getting at, no. That's a good description of it, as far as it being offensive rather than defensive. You're setting up that defense for later, so the underwriter can see that defense is there, and it's very clear, and it's going to be easy if we ever have this come up. So the allegations in a quiet title complaint are essentially, you're waiting until the redemption period is up, first of all. But you're saying that I bought this property at a tax sale. Everything was fine with the tax sale. It's made it through the redemption period. The delinquent taxpayer was this person by virtue of deed of record and whatever it was. And there were also these two apparent liens on the property. The natural effect of the tax sale and the ending of the redemption period is to extinguish all their interests and to give me perfect title on the property. That is now the case. However, because these interests still appear on the public record, there are apparent clouds of title that affect the marketability. Therefore, judge, please enter a declaratory judgment saying that we have perfect title in this property, that all these apparent interests are clouds on title and should be cleared off, quieted, and we should be able to record your order saying that we now have perfect title to this property. And the res judicata defense is something that's for later. But that's the basic, strategically, that's the idea of it. That's what you want to achieve, is that if somebody comes in 6 months later and says, wait a minute, I didn't get, they didn't serve me. It was unclaimed certified mail, whatever else. I remember seeing this thing with the quiet title, but I don't know what quiet title is. I didn't respond to it because I was busy. Then they can say, well, it doesn't really matter that you weren't served properly in the tax sale. You were served in this quiet title lawsuit, and you should have brought that up then. And because you didn't, your claim is dismissed. So that, I think, is the true value of a quiet title. But, sir.
I'm sufficiently intimidated. So if I go to the Williamson County tax sale and I'm looking at the property I like, how much do I factor in for legal to get the title?
I would love to be able to say it's a flat rate of X. The problem is, especially if you file a quiet title action, going with that idea of producing that res judicata defense for the future, that res judicata defense means, you should have brought it up then, so somebody might bring it up then. And so it can go off in all kinds of different tangents. Now, if you look at something where it's very straightforward and there are no problems getting people served and nobody fights you and it goes right through, you may be getting out of it $1,500 to $2,000. But, you may end up with a counterclaim that's still there a year later and you're still fighting it, and it's just like it turns into a big lawsuit. So, unfortunately, it's not something that lends itself to a flat fee arrangement. I would prefer it were, because it would make it a lot simpler to do. But it's too nebulous. It can go in too many different directions. But I'd say for the most part, it doesn't end up getting all that expensive, because a lot of times, things that make it to that point, nobody's ever stepped forward before. More often than not, they're not going to step up now. So the majority of them do not get a whole lot of resistance.
You mentioned there was recourse for if you maintain the property during the redemption period and it's redeemed. Is there recourse from the redeeming party if the property is destroyed? What if I buy it?
Sure. There is recourse. It wouldn't be covered by the tax sale laws. It'd be other principles of law that would apply there. I think that somebody could hit you with a suit for waste, negligence, all kinds of other things, depending upon the type of damage you did to it. And the statute used to make very clear that you had an obligation to avoid waste of the property, avoid permissive waste. And that's still a principle that applies, and that idea kind of jumbled the idea of maintenance versus, of whether you were maintaining or you were improving something. And it was read together to say if you were doing it to avoid waste, then you were maintaining, and that just created all kinds of confusion. But yeah, I mean, you're potentially on the hook if you damage the property.
Intentional or unintentional matter.
Well, intentional, of course, is going to be worse. But I mean, that's a case-by-case thing as well. Really, what is more of an issue there is the risk of loss, where if something happens, you may not have any recourse, and you're stuck with it. And you're stuck with this property that now has a meth lab quarantine. And
Because, let's say you buy something, you get it insured, and say it burns down, and they redeem, are they entitled to that insurance money, even though, it wasn't theirs at the time? Is that, like, sort of?
probably depends on the policy and who's a named insured and so forth. I don't know. Sir?
There are violations of local ordinances related to the way you care for the property.
Mm-hmm.
Every now and then, some municipality or county will come and say, we're going to cite you for not having done this and not having done that.
Yeah.
When you get that first, when you get that redemption period over, those all become your problems.
Yeah. If it happened during the redemption period, yes. If it happened before the redemption period, it goes away in the sale, just like a junior lien. What happens here is you'll get a notice of violation and they can record a lien on it. If those were before the sale, that's just like any other lien, it goes away. You don't have to worry about it. If it happens during the redemption period, if it's after the sale, that's different. And you have to deal with that. But one of the things that happened legislatively, either last year or the year before, one of the provisions made clear on that list of items that are maintenance and are reimbursable, that one of the things was expenses incurred in order to bring a property in compliance with local, I forget the wording, but essentially, if you pay that then during the redemption period and it gets redeemed, you're getting your money back. So that's arguable. Probably not. There's a way, and I could go into all kinds of different weird permutations of this. You can get, if you pay, like let's say for instance, it's a 2012 tax sale and you buy it and you go in and you pay the 2013 taxes, that's reimbursable. And I could make an argument for you that you should get penalty and interest on that under the state statute because you have a subrogated right because you've paid taxes that were the legal responsibility of somebody else. There's nothing in the statute that says you get interest on the on any of those maintenance expenses. And quite frankly, it'd be pretty unwieldy to do that because you'd have to basically require everybody to have a specific receipt with a date on it for every single expense, which probably should happen anyway, but it becomes a real calculation issue. And I don't know who here deals with clerk's offices at courthouses a lot, but they generally tend to be pretty overwhelmed with this kind of stuff. And you start putting those kind of calculations on them, you're going to get some pushback. So, yes, ma'am.
I think I missed how the bidding works. Since it's a sheriff's sale, does everybody go and bid up on it then?
Yeah, the way it works is it's conducted by the clerk of court, the clerk and master of the chancery court. So for instance, it's supposed to be held on the courthouse steps or inside or whatever. And you go, in most counties, you fill out a registration form. And a lot of times what they'll want you to do is they'll want you to sign what's essentially a contract saying that if you bid, you're on the hook for it. Because some counties have had problems with people having winning bids and not paying. And the clerk will have a list of however many properties are being sold that day, and they'll call each one by one. And they'll say number one is, and they'll describe the property, and they'll say the opening bid amount is $2,378. Are there any bids? And this guy over here will bid that amount, and then somebody else will bid 2,500, and, and whoever, it's just like an auction, whatever the highest bid is the one that gets it.
What happens to that overbid? Does the former owner?
No, that is, and we could have several slides on that very issue. But that money sits in court. And there's a statute that's about 2 years old that sets forth priority rules about what happens with that, because that was causing all kinds of other problems about what happens with that, of the overage money. But essentially, it's supposed to mirror regular priority rules. So let's say, there's $2,000 of overage. Anybody that has a right of redemption or an interest can file a motion with the court asking for that money to be dispersed. You can do it during the redemption period, and if you claim your money, you've waived your right to redeem, or you can wait till the redemption period is over. What's the priority order is the county or city gets paid first for any subsequent taxes on the property. And we try to use that to get stuff taken care of with varying degrees of success. Second is lien holders that had an interest before the tax sale. Third is subsequent lien holders. And then if any money's left over, the delinquent taxpayer gets it. So it's supposed to be commensurate with the delinquent taxpayer's level of equity they had in the property, so they aren't getting unjustly enriched. There have been some judges who have seen it very differently and thought that the bank ought to get kicked out and that they should give $40,000 to this person who hadn't paid their mortgage in 3 years. And then what happens a lot of times is that nobody will claim it, and that money gets held in court for I don't know how long, maybe another year. And there's the Uniform Disposition of Unclaimed Property Act, and it escheats to the state, and you can make a claim on it there afterwards.
We get interest on that overage?
On the overage, no.
No, just the base amount.
Yeah, who's going to pay the interest? Yeah, and you're not going to go after the buyer to bring in more money. So it sits there. And the idea being that you can, as soon as it's there, if you want to waive the rest of your redemption period, you can come in and get it.
What can you say about how the liens are sold front end of the process? Do the cities and the counties both sell, or?
Well, generally, it differs by county as to whether they're acting together or not, and whether you have a county tax or city tax or both together. The only pre-tax sales of liens are generally done en masse. Where, like, for instance, Davidson County here in Nashville, they sell their receivables to a third party who pays some premium on them, that Nashville still does the work to collect the taxes, and they're obligated by their contract to do so. There's a statute that allows counties and cities to sell receivables that way and to essentially establish Tennessee could switch to a tax lien or tax certificate type deal without probably a whole lot of additional, well, I'm sure there'd be a lot to do, but the framework is already there to do that if Tennessee really wanted to, but there's a lot of inertia. Things have been done a certain way for a long period of time. People don't want to have to reconfigure all the different clerks' offices to deal with this stuff and all that. So I don't see it moving to a tax lien or tax certificate system anytime soon. But I think that if you want to do it that way before the public auction of the actual property, that's really about your only opportunity is to get in on the Metro bid of the receivables, which they usually do a couple of years in advance, I think. All right, any other questions? All right, well, thank you all very much. Our firm services these areas. If I can be of assistance to any of y'all on anything, please let me know.